So just want to welcome Commissioner McGrath. I'm going to see if I can remember all of the remits that you have. So he's Commissioner for Democracy, Justice, the Rule of Law, and Consumer Protection. So thank you for coming here today. It's really an honor to have you. It's also a special timing. The GDPR also has been 10 years with us. It's probably the best example of the Brussels effect, but also it has been also an example of a very challenging implementation and also up for review. So there's more and more work coming our way. So please, Commissioner McGrath, sure. Please join us.
Well, thank you very much, Ezekiel, and good afternoon, everyone. Please do continue to fan yourselves because I would be doing the same if I was down there. It's very hot out there. But it's wonderful to be here with you all this afternoon, and can I thank you for the invitation and congratulations to Cullen International for marking 4 decades of growth, beginning with one man, one idea, and 3 letters, and now enjoying a global reach of thought leadership, carrying forward Bernard Cullen's legacy and upholding the values of neutrality, accuracy, clarity, expertise, and efficiency. To me, what underpins a reputation of expertise and honesty is trust. Trust in the experience and the insight of the advice provided. Trust in the neutrality and consistency of the intelligence produced. Trust in the transparency and impartiality of the role played. I see this because trust is the value that unites pretty much everything under the very broad portfolio that I hold within the European Commission. Where the rule of law is upheld, where democracy is protected, and where fundamental rights are respected, there is also trust. Whether this is trust in legal frameworks, trust in free and fair elections, trust in stable markets, or trust in consumer choice. Nowadays, trust has become a strategic asset, but also a competitive edge. At a time of geopolitical instability, trust is a response to disrupted supply chains, strategic dependencies, and contested global markets. Because the value of stable, predictable markets and partnerships we know has risen in the world in which we live today. So how does trust relate to better regulation is a key question. Trust also underpins regulation that is necessary, transparent, and proportionate. Today, Cullen International celebrates 40 years. During this time, Europe has grown into the world's largest single integrated market of 450 million people. This scale allows Europe to stand toe-to-toe with its continental competitors, firmly rooted in a broad base of market access, highly skilled workforce, and world-leading research capability. But today we are talking not about good regulation, but about better regulation. Europe's competitiveness will be shaped not only by the rules that it adopts, but also by how well those rules are understood, how consistently they are enforced, and how much confidence that those rules deliver in practice. This places Europe's competitiveness drive, which is central, as you know, to the mandate of this European Commission that is in office 18 months, alongside our simplification agenda. Simplification is about making EU rules easier to apply, but also less burdensome to deliver, all without lowering the underlying policy objectives. Simplification is not a deregulation. It is about better regulation. And the European Commission delivers better regulation by achieving consensus where we can. European regulation is not decided in a backroom. Europeans discuss, debate, and adopt them democratically, sharing their views through public consultations, directly electing members of the European Parliament to represent the electorate of our 450 million people, and dispatching representatives from elected governments of each and every member state of the European Union. And once adopted, regulation is subject to evaluation and often revision where that is deemed to be necessary. So while there is always a line to be drawn and a balance to be struck, I'd now like to provide you with an insight into how I'm leading better regulation under my own portfolio within the Commission. Firstly, through the digital omnibus as part of our simplification drive. Secondly, with the EU Inc. proposal as part of our competitiveness drive. And finally, with the upcoming Digital Fairness Act to close the consumer safety net and protect our children online as well as offline. When it comes to data protection, the EU has not only shaped a human-centric and rights-based approach, but shaped global standards in doing so. Secure and stable data flows underpin all modern services today. But where data flows, it is vital that rights accompany that data. This approach to data protection as a fundamental right has been enshrined in the EU's General Data Protection Regulation, the GDPR, which I think it's fair to say is now acknowledged widely as a global standard. But in an evolving data economy, the regulatory framework often needs to evolve too. And this is why the European Commission presented targeted amendments to the GDPR in the so-called Digital Omnibus in November of last year. We did not touch the core principles or requirements of the GDPR. Overall, I think it has served us well. We focused on facilitating compliance, easing application, therefore reinforcing confidence. Through targeted measures to enhance legal clarity or simplify obligations for data controllers, we also aim to strengthen compliance. This was all the while respecting the GDPR risk-based approach and the fundamental right to data protection, upholding trust in legal certainty and in secure data flows. And by delivering better regulation internally, we have also been able to project this outwardly. So in the last year, I have been to opposite sides of the world, to Brazil and to Japan and South Korea, to open up our network of free and secure data flows. This is how better regulation of the data economy has not only protected fundamental rights, but facilitated secure data flows. It has also made the GDPR one of the EU's most trusted exports in the world today. Estimates put EU adequacy decisions, allowing personal data to move freely and securely, at boosting digital trade by approximately 14%. Better regulation does not stop with targeted amendments to existing legislation, but also begins with new harmonising legislation. And back in March of this year, I presented what is regarded as a central pillar of the Commission's competitiveness drive, a 28th regime corporate legal framework, which we now call EU Inc. It responds to the situation that founders of companies in the European Union today face, and also what investors face. 27 different national legal company law systems, and actually more than 60 different company forms are available in the European Union. For too long, regulatory fragmentation and unnecessary burdens have dissuaded Europe's talent, ambition and innovation from setting up in the first place, or from scaling up, and sometimes from staying in Europe as they grow. We've heard directly from companies that they need simpler, faster, but also more predictable rules, and the EU Inc. proposal is designed to respond directly to those needs. There are four main ways that the EU Inc. proposal will make this a reality. First, companies using the EU Inc. legal form can set up quickly and cost efficiently. Quickly means the ability to register online within 48 hours. Cost efficiently means for no more than €100 and with no minimum share capital requirement. Second, EU Inc. will be fully digital and require information to be provided once only. Fully digital means corporate processes throughout a company's life cycle, from registering and submitting company information through online shareholders and board meetings to digital and simplified winding up procedures. The once only principle means that companies will submit information to business registers just once, and those will transmit them to other national authorities then. This will cut burdens on companies, but also will serve to enhance the safeguards against abuse. Third, EU Inc. is about talent. EU Inc. will help companies to compete for and retain talent by issuing employee stock options, with employees being only taxed on the gain that is realised once the shares have actually been sold. So we're proposing a harmonisation of the timing of the tax liability under the proposed new EU employee stock option scheme. Fourth, EU Inc. is about investment. It is the oxygen that businesses cannot survive without. The EU Inc. proposal provides fully online procedures without mandatory involvement of intermediaries for share subscriptions and for share transfers. This will allow founders to raise equity efficiently, including through early stage financing instruments. EU Inc. companies will also be able to have their shares traded on SME growth markets and multilateral trading facilities. At the same time, the EU Inc. proposal offers a balanced corporate framework with safeguards to ensure that it is secure and reliable. It fully respects, for example, the existing rules on employment, social security, social protection, taxation and anti-money laundering, as these rules will apply to EU Inc. companies in the same way that they will apply to any other company. We face an ambitious timeline to reach an agreement before the end of this year. This is called for in the recent One Europe, One Market roadmap. The European Council have also called on the Commission, the Parliament and the Member States to deliver a political agreement by the end of this year. It is ambitious, but it's doable, and I believe that we can make it. If we do, we will show how a better regulation of the innovation economy will make the single market the trusted place for founders and investors to set up, scale up and to stay in Europe. But better regulation does not stop in the field of corporate law. Just as the trust that companies have in the single market gives the EU a competitive edge, so too does the trust of our 450 million consumers. And yet, consumers now face what we regard as a complex environment of unfair practices online, especially our children face them. Digital markets have revolutionised everything from communications to governance. But they've also created incentives for business models built on manipulation, opacity and addictive design. This presents risks and harms to users, undermining trust in digital markets. But consumer trust is not a soft concept, it is a market condition. And this is why by the end of this year I will present a Digital Fairness Act to the European Commission. The DFA will strengthen the safety net of consumer law, which applies to all companies irrespective of the technology or the business model. It will also address problems such as dark patterns that can unfairly influence the decisions that consumers make. The addictive designs incentivizing consumers to spend more time and more money online. Unfair personalization practices and misleading pricing practices. Problematic influencer marketing that is not sufficiently transparent. And difficulties with managing online subscriptions, something we can all relate to, where we sign up to a free trial period and it automatically rolls on to a permanent commitment. The protection of children, as you know, is a priority for this European Commission across all of the policy areas. A particularly prominent topic in public debate at the moment in Europe and beyond is the question of an age restriction for social media. This is why the preparation of the Digital Fairness Act is progressing in parallel with the work of the expert panel that President von der Leyen set up to examine the question of child safety online. And we anticipate that they will report in the next 3 weeks or so to the Commission. As I said at the outset, for generations, specific standards of accountability, responsibility and care have protected children from risks and harms offline. We now simply must do the same online for this generation of digital natives and for the future. We must be bold while making sure that our interventions remain evidence-based, proportionate and firmly grounded in better regulation principles. Our work will help reinforce consumer trust and allow us to trust that our children can navigate their way safely through digital markets. Ladies and gentlemen, with this I would like to close because I hope I have shown how better regulation has built and will continue to build a better world, whether in the data economy, where fundamental rights are protected and secure data flows are facilitated, in the innovation economy, where our single market will become the trusted place for founders and investors to set up, scale up and to stay in Europe, or indeed in the consumer economy, where updating our laws can reinforce consumer trust and protect the vulnerable for everything that they face in a very challenging world. So thank you once again to Cullen International for the invitation to be here today. Thank you for your patience in what I know are very trying and challenging circumstances with the temperatures today. But congratulations to Cullen International on reaching the very significant milestone of 40 years, and I wish you all the very, very best of luck over the years ahead in the next chapter of no doubt growth and productivity that you embark on. Thank you all very much.